Montana Villas is a 22-unit condominium association located in the upscale Brentwood neighborhood of Los Angeles. In October 1997, the Board of Directors of Montana Villas HOA agreed that new rain gutters should be installed as recommended by their management agent, Pegasus Management. Pegasus hired Mark Ruby, who owned a business called Rube's Rain Gutter Service, to install the new gutters. Unfortunately, Ruby was an unlicensed contractor, and despite having employees, he maintained no workers' compensation coverage. The job should have only taken 2 days and cost the association $1,050. Ruby hired Freddie Aguilera to handle the installation. Freddie was promised $65 a day. On November 5th, 1997, the first day on the job, Freddie contacted a high-voltage electrical wire while holding a length of rain gutter in his hand. Freddie was not only nearly electrocuted, but he fell off the ladder and sustained serious injuries in the fall. Freddie's boss, Mark Ruby, came back to Montana Villas to complete the job and was paid by check. Aguilera filed for workers' compensation, naming Ruby as the employer. However, it was determined that Ruby had no workers' compensation coverage in force, and the Uninsured Employers Benefits Trust Fund stepped in to pay the claim. The Workers' Compensation Appeals Board determined that Ruby did not possess a valid contractor's license at the time of the injury, and thus, under Labor Section 2750.5, Montana Villas became Freddie Aguilera's employer. Section 2750.5 of the California Labor Code states that any person performing any function or activity for which a license is required shall hold a valid contractor's license as a condition of having independent contractor status.
The Uninsured Trust Fund is designed to be a safety net for employees who, in good faith, are working for an employer who has violated state law by failing to have workers' comp coverage. If Montana Villas was deemed to be the employer but had no coverage, the Uninsured Trust Fund would step in, pay the benefits to the injured worker, then place a lien on the property equal to what was paid out. No owner in the community would be able to sell or refinance until that lien was satisfied. This is why condominium associations and planned communities should maintain a workers' comp policy as a safety net, even if they have no employees. The association could be deemed to be the employer in the most unlikely circumstances. Bear in mind, a workers' comp policy will not only cover unexpected losses, it will also serve to mediate the amount an injured worker can claim. That's the trade-off. In exchange for an employer providing no-fault coverage for work-related injuries, their employees must accept the statutory benefits, as determined by the state for certain types of accidents or diseases, and they may not sue the employer for damages beyond those benefits. On the other hand, if no workers' comp policy exists, there's virtually no ceiling on the amount for which an injured worker could sue his or her employer, including damages for pain and suffering. So workers' comp insurance limits the claim and pays the loss. We think of it as protecting the worker, and it does, but it also protects the employer. Perhaps most importantly, this is a legally mandated coverage, and there are fines and other forms of punishment for employers who fail to maintain it. Almost all CC&Rs require the Board of Directors to purchase workers' comp to the extent such coverage is required by law, and the law indicates you must maintain it if you have employees.
The challenge is determining what constitutes an employer-employee relationship. In the state of California, there are at least a dozen tests of this relationship, and you only have to meet one of those tests to be deemed an employer at the time of loss. Recognize that different entities like the IRS may have a different definition of employees versus independent contractors. But for the purpose of workers' comp coverage, as mentioned earlier, if the job requires a contractor's license, you must hire a licensed contractor or become the employer by default. This was decided in the 1985 case State Compensation Insurance Fund versus Workers' Compensation Appeals Board. And surprisingly, this may hold true even if the contractor has misrepresented the fact that they are licensed and insured. In other words, if a contractor were to provide a forged proof of insurance, or a certificate for a policy that has since lapsed due to non-payment or for some other reason, the association could unwittingly take them on as a direct employee. proof of workers' compensation insurance is a requirement of the California Contractors Licensing Board. So verifying that your vendor's licenses are valid and in good standing is an excellent first step. But a no-payroll workers' comp policy acts as a safety net to protect the association in the unlikely event that that is not enough.
Here are our recommended best practices. First, implement a vendor bid process in which only qualified vendors are allowed to submit proposals to the board for consideration. If you're a management agent, be sure to always have a board member sign the actual contract. This will avoid inadvertently inserting yourself into the equation. Second, maintain a minimum premium workers' comp policy. Like all insurance coverage, this is coverage that you don't know you need until you need it. But given the unpredictability of these types of claims, especially here in California, we believe it's well worth the limited annual expense. Remember, there is no coverage under a general liability policy for these types of claims. General liability policies have specific exclusionary wording for work-related injuries. Directors' and officers' liability policies also invariably contain outright exclusions for bodily injury or sickness, whether it's work-related or not. There is also no coverage afforded to the association under the management company's workers' comp policy. Workers' comp policies do not name additional insureds unless a direct ownership exists between the two parties. If the association has uninsured or unlicensed contractors, the compensation paid to those individuals will be reported at the time of audit, which occurs at the end of each policy term. The HOA should always obtain certificates of insurance evidencing workers' compensation coverage and check the vendor's license before the work commences at www.cslb.ca.gov. The bottom line, we won't know until the time of injury if a worker could be deemed to be an employee of the association. Maintaining a standalone no-payroll workers' comp policy is the only sure way to protect the association from a work-related injury claim that could run hundreds of thousands of dollars.